topic is best practices and tips for winning at the PTAB. So we have joining us here today. Allow me to introduce the panel, and I will start in the inverse order that we normally go. So I can introduce Judge Grace Oberman first. Thank you for being here. Judge Oberman is an administrative patent judge on the Patent Trial and Appeal Board at the USPTO. Next to her is Stephanie Schoenwald, who's a partner at Choate Hall and Stewart. And then last but not least is Scott McEwen, who is a shareholder at Wolf Greenfield, and he is the proprietor of Patents Post-Grant blog.
That's right.
So thank you all for being here today. We have on tap a wide open discussion about the PTAB and about how to win at the PTAB and everything that you need to know. And Judge Oberman is going to tell us all the secrets that we need to do to convince her and her colleagues that we are deserving of being winners. So what I'd like to do before I kick it over to Stephanie to kind of lead us is ask the panel to give us your preliminary thoughts on the topic. When you hear the topic winning at the PTAB, what is the first thing that comes to mind that you want to share with the audience? We can go with you, Scott, and then I'll give Judge Oberman the final word on the preliminaries, but take it away.
Sure. I think the first thing that comes to mind to me is well, it's like any forum, is understand the forum, understand what the judges are looking for, and understand, probably most importantly, that this is not a district court, and I don't mean that pejoratively. It's a different analysis. It's very, I often refer to it as an obviousness court because, 9 times out of 10, that's what you're talking about, and you're having technical conversations with judges that understand the technology. So especially from the patent owner side, it's really critical to understand where you are and what the standards are and, what the analysis is in terms of this isn't the district court, and some of the things that you do in the district court are not going to resonate with these judges, and I think that's a lot of the disconnect that's out there in the public. It's, well, things have worked a certain way in the district court for so long, and we're all very accustomed to that, and when we go to the PTAB, it doesn't work that way, therefore it's wrong. And I think that's part of the issue with, a lot of these discussions about how the agency should work as compared to the district court. Is it litigation? Is it not? And ultimately, it's a patentability determination, very similar, if not identical, in a lot of respects to what happens during patent prosecution. And so you need to be able to speak that language to be successful at the PTAB. And while there are aspects that are, very similar to litigation, there's depositions, there's limited discovery. It's really all about the claims and the technology, which is not always the case in the district court.
Great, thanks a lot, Scott. Stephanie, your preliminary thoughts.
Yeah, I'm going to follow off a point that Scott made, which is the APJs are technically trained, and the science and the technology matter in this forum, and particularly because in the life sciences, we've heard throughout the day today about the tensions between obviousness, which is often a ground that is presented there, but more and more in the life sciences, for the reasons we've been talking about, Amgen, Juno v. Kite, we're seeing an increase in those 112 positions. And so understanding which of those is the right one to take forward, explaining the state of the art and how you're going to get there, and helping the judges to really understand the technology both in your case and in the prior art is incredibly helpful. So making sure you're taking the time to really think about how to present the technology to people who will understand it.
Great, thanks. Your Honor, your preliminary thoughts on the topic.
Well, listening to Scott and Stephanie, I think that I agree with everything they said. Scott is talking about the differences in the district court versus the PTAB, and I know that our presentation today is talking a little bit about how narratives can be used in the district court, and I'll have more to say later about how I think those same narratives can be especially persuasive before the PTAB in the life sciences area in a particular context. I won't go into it now. But also, I think that Stephanie was touching on the use of experts, which is the other, critical thing here that's on our slate today. And I'll have quite a bit to say about that as well, because I think there are ways that people that are practicing in the life science space can make very effective use of the expert declarations in the PTAB, and it will be a bit different from the district court.
Great, thank you. Now, Stephanie, I'll kick it to you
Yeah.
to take over.
Sounds good. So you've heard from all of our comments that experts and understanding technology is important, and it's particularly important in this space. And one of the things Scott and I had talked about quite a bit is a difference in the importance, at a high level at least, of the expert in a unpredictable art case versus a predictable art case. But expert declarations, not expert reports, to Scott's point, are prevalent and everyone uses them. So Scott, I know you had recently written an article about expert declarations and how they can be effective, and certainly something you should not do. So I'm going to kick it over to you to address that.
Yeah, I think the practice has become, I do this myself, everyone sort of does it, is the expert, the declaration of someone of skill in the art starts to look like what you see in the district court, and that there's claim charts and people are taking positions, well, I think this is obvious, and making conclusions of the law. But I think what they should be, and Judge Oberman can certainly comment to this, is what the judges are looking for, at least from my perspective, is scope and content of the prior art. What's the background? How did the technology evolve? What is your understanding of this reference? What is your understanding of the design reasons, to go in the direction that you went in when you're, if you're the challenger, in trying to prove up obviousness. So it's a lot of the, sort of the connecting tissue to the ultimate ground that's important, not so much some expert saying, well, yes, this claim chart is 100% correct, and I'm just going to adopt all of the positions that are in the petition, and it's going to be word for word, just parrot back what's in there. And attorneys like to do that for consistency, write the petition and the declaration say the same thing, so we won't get tripped up in a deposition. But ultimately, as evidence, it's not persuasive, because you're not really coloring in the blank space and giving the judges what they need to say, well, yeah, I understand, I can read the claim chart, I understand the technology, but what I may not have as much experience in is the market dynamics and what was going on and what was driving the technology in a certain direction and why this combination you're presenting makes sense. And so, your best bet, or I should say your best practice, at least on the petitioner side, is to focus on that kind of technology-focused story of what's going on in the art and what were all the various design considerations.
Yeah, I love that, because it's one of the things I find to be most helpful, again, because we're in the unpredictable arts, is something, did the field understand it or did they not? It's really helpful to sort of set that stage. Here's what's happening. And there are cases where I think it's interesting, because you may have we've seen where this art actually kind of flips at a certain point in time, meaning, there's plenty of literature everybody can find out there from 2010 that says, we don't know how this works, it's unpredictable. And so if you're using that type of art to set it up, as a patent owner, you should be certainly coming back with, that was great in 2010, but in 2020, everybody knew how to do this, and it was predictable, and so it really does help to explain exactly what the state of the art is, going up to the relevant date that you need to address. And we've actually even seen it the reverse, where there was early on articles where somebody was saying they expected something to work, and then people tried it and it didn't work, and then that raises a whole nother interesting way to look at the state of the art. And those types of pieces of information and helping walk through that type of the timeline order, is I think is particularly helpful for, reconciling for the panel, for example, why one party may be putting forward art that says predictable and the other is putting forth art that's saying unpredictable. And I don't know if you've seen that, or you have thoughts on how we can best set those stories up in
expert declaration.
Right. Well, I do agree with what you all said. I think it's I encourage everyone to read Scott's article on it. I thought it was very good. I wanted to just make sort of two comments that key off of what Scott and Stephanie have already said. And the first relates to the Xerox versus Bytemark case that the director put out. Scott alluded to this idea that, you might not want to repeat verbatim in the petition or in the expert declaration what's stated in the petition. I take sort of a historical view of Xerox, and I think what really happened here, those that have been practicing in the PTAB space for some time will recall that early on, probably back in 2013, the board started complaining that, or actually parties started complaining that people were trying to incorporate by reference into the petition a lot of stuff that was said in the expert declaration, and we sort of scolded people for doing that. And I think they're developed a practice of actually doing this verbatim stuff because litigants were afraid they were going to be accused of incorporation by reference. Balanced against that, also very early on, probably around 2014, there was a judge on the PTAB, and I won't mention her name, but she's great. She put into one of her decisions that you can't sort of cast expert opinion as fact simply by giving it the veil of the ordinary artisan. And then you started to see other judges quoting that all the time, and we would say, the veil of the ordinary artisan doesn't elevate conclusory testimony to fact, and we're not going to give it much weight. And I was hearing at other conferences, people didn't understand that. They were like, what are you trying to tell us? And I think that Xerox was a reaction to that, because Xerox sort of takes those concepts, and if you read very carefully the decision, what the director said there, and I want to explain it for you all. I think a lot of you already are getting there, but in case there's some confusion, Xerox is not a prohibition against using a declaration that repeats what's in the petition. It simply is stating for the bar that the board is not going to give much weight to it unless the opinion is supported by objective evidence or technical reasoning. And that's exactly what Scott was just saying, that we are going to be looking very carefully at the expert declaration to make sure that if it's a statement that would be attorney argument, that there's a reasonable amount of support for it in the expert declaration. So simply repeating it as an ordinary artisan or somebody who understands the level of skill in the art isn't going to elevate a factual statement to truth unless you can point me to a document that supports it or some kind of technical reasoning that will convince me that you're right. You can't just say it. Whether you're going to include that support in the petition is another thing. Different judges have different tolerances for this, but basically if it's a simple fact, you might not have to repeat it in the petition, but if it's something that's the crux of your case, I would say you might want to repeat it in your petition and have that evidence in there. Going on the thing that I wanted to say, I think that especially in the unpredictable arts, what I see a lot with expert declarations is an attempt to backfill a limitation that's not there in the art, and that's going to give you problems because we're not going to allow expert testimony to replace the actual disclosure of what's in the prior art. So like Scott was saying, it's great to sort of build a story around the prior art, but if you get into a position where we have to rely on your expert testimony to backfill a limitation that's not in the art, you're going to have a problem. And the other place I see problems in the unpredictable arts is oftentimes you won't have an express statement in the art that something is happening, like a function, and the expert will try to backfill it in with inherency. And in the beginning, we would see, there was an old case in Ray Brown where the examiner could throw back at the applicant and say, we don't have the resources to prove that this would have actually been inherent and necessarily happening in this prior art combination, and we would require the applicant to come forward with some evidence of that. In the beginning, we would see petitioners trying to take that same position and not come forward with evidence and try to adopt the examiner's presumption of lack of inherency and try to throw it on the patent owner, and we won't do that. When you file your petition, if you're relying on an inherent feature, you're going to have your expert come in with hard data that that's necessarily happening in the combination. And you're not going to be able to throw it onto the patent owner to make them come forward with evidence that it's not happening. So what I will see sometimes is a battle of the experts, and one expert will say, look, this would have inherently been the result of the combination, and here's some test results that show it to be true. And then you might have the patent owner come back with their expert and say, well, here's some other combinations from that same art, and it's not happening. And if that's the situation, you're going to have probably a decision where it's not necessarily the result, and it's going to really, really depend on the strength of those expert declarations.
I want to piece out a little bit of both of those points because I think they're great. So the first question that I have for you is, and I thought that setup about how we got to verbatim feels very accurate to me. I remember responding to are you writing too much in your expert declarations, and how much of that can you boil down? And I do think it still seems reasonable to say you have a paragraph with a good, your topic sentence, your punchline, right? And then the expert provides their thinking around that. That doesn't feel to me like incorporation by reference. Is that the right level? Is that how you guys think about it?
Yeah, I do. Let me put it this way. I've seen petitions that will say, it would have been obvious. See declaration paragraphs 20 through 230. That is incorporation by reference, okay? That's an extreme case, and I've seen it.
Wow.
But what I really like is a petition that doesn't feel that they have to say everything that the expert is saying, but will give me some, something really good to hang on to. And then when I go to the expert declaration, it'll cite maybe one or two paragraphs of the expert declaration. And when I go to that declaration, they'll say the statement, but then they'll say, here's an article about at the relevant time that supports what I'm saying.
Yeah.
Or it doesn't have to be that type of hard evidence. It can be technical reasoning. If I can understand it and it makes sense, and if it's not challenged by the other side, I'm going to presume it's probably accurate. That is really nice to sort of put some meat on the evidentiary meat on the bones that might be distracting in the petition.
Yeah.
Can be very effective when it's presented correctly in the expert declaration.
Yeah. And how about, explanations of the technology? So we often would have, for example, a background of the technology section in a petition or even in the patent owner's preliminary response. But oftentimes, I think my inclination is to expand upon that in the expert declaration as well, to really kind of give the board the roadmap that we've been talking about the state of the art, or understanding particularly tricky features. Mm-hmm. Is that kind of thing helpful for the board? And are there ways we should be thinking about, taking a stab at that so that we're most helpful? Yes,
it's especially helpful when I have both parties, especially if it's a really difficult technology and one that I might not, have a lot of background in. Mm-hmm. It can be really helpful if both parties do it, because I like to see whether one party is contesting something about the background of the art that the other party is raising. Yeah. That can be especially helpful. And when I'm writing my final written decision, I usually try to use the background section from the loser's brief, because I want to make sure that they understand that, I understand what their position is from the background. I'm always writing for the loser. Yeah. And I want to respect the loser's position because they're the ones that, I'm really speaking to, and the Federal Circuit. But I want to make sure that the loser, goes away from my decision feeling like I really understood their side. I just simply disagreed with it, but that they got it across. It's not a stupid argument. It just didn't carry the day. So I'm always trying to write for the loser. And when I get to that background section, I'm trying to use the loser's presentation of it to the extent that it's not contested by the winner. Mm-hmm. So if you can keep that in mind, I'm really looking for the any kind of contrast between what the two parties are presenting in the context of background.
Excellent. And is that consistent with what you're doing, Scott?
Yeah, and I think at least in the predictable arts, I would say that the background section is probably even more important after the recent Axonics decision of the Federal Circuit, which sort of clarified that, if a patent owner comes in and starts arguing a claim construction, essentially for the first time, or, the petitioner hasn't seen it before, they can adapt their ground within reason to address that. And if you've got a robust background of the invention, a lot of times there is art in there that's describing, motivations or developments in the art that you may be sort of adjusting to. And having that in there and the patent owner being on notice of that, I think just gives you more credibility to the extent that you have to say, well, look, yeah, they're arguing this claim construction and, this parameter is not in memory A, it's over here in memory B, but, as I've shown you in the background, all of these considerations, this was just a design choice where to put it. And so, having a lot, you don't want to overdo it, obviously, but if you tell a coherent story, a consistent story, and you have the corroboratory references in the background, I think should you find yourself in that axonics position, it just, to me, it comes across as more credible as well. I'm not just sort of going in a different direction. This is a consistent story to what I've always told. So I think, my view is that's probably the most important part of your declaration, in addition to your motivation to combine and expectation of success and all of that. But in the unpredictable arts, it may be not quite, not as valuable in the same way, because those claim construction arguments, you're not going to see as much there.
Right. What about secondary considerations? Because that's another thing that can get built into those types of sections that, again, an expert might be able to opine upon without really getting, to having to have a section all its own, reaching.
And that's another one, I think,
conclusions.
where your mileage is going to vary depending upon if you're in the unpredictable arts or the predictable arts. You're probably going to, not always, but probably have a separate expert for that. If you're talking about market share or, all of this, commercial expectations of success and sales levels and all of that, you're probably going to have a different expert for that. But I will say, and again, this is more from the predictable art perspective, secondary considerations are argued a lot, I think, more as a tactic to burn up the page limit of the other side, because to do it correctly requires a lot of effort. And like I said, if you're talking about commercial success, what was the market share? What was the marketing budget? It's really difficult to sell in a lot of respects in the predictable arts, where in the unpredictable arts, right, if you've got a drug formulation, it's definitely a little more easier sell there to show, well, hey, here's the efficacy from the old one to the new one. So I think in the unpredictable arts, there's a lot more mileage to be had on secondary considerations.
I think I agree, and I think one of the things that I would note there is, we have in the past raised things like commercial success, but more often we end up raising things like unexpected results or criticism in the art again. So for me, a lot of that does end up folding into the background, because that's where you can start to set up the failures of others and what people were saying about the potential solution and whether or not it truly was expected or what you're going to be comparing to, all coming into the invention that's at issue. Thoughts on secondary considerations?
Yeah, I did want to talk about this because I think, especially in the unpredictable arts, this is one place where the narrative can really be useful. I know that Scott was saying in his article that he doesn't think the use of narrative before the PTAB is particularly effective. I've seen it used very, very effectively in the secondary consideration space or objective indicia, where you actually do tell a story of industry praise. This is a situation where I've seen up to 3 or 4 experts that are simply there to provide the data. Mm-hmm. And a lot of times in the life sciences space, there is a lot of data on secondary considerations, objective evidence. And there, I think you have more leeway to put it in the expert report or the expert declaration and, be a little bit more conclusory in the petition. Not so conclusory, but, you can say we had this % of market share, and then you can bring in, the expert that can establish that in the deck. Now, what I see a lot of times, and I hadn't thought about the idea that it was a strategic thing to make the other side have to burn pages, but usually the objective indicia will come up, in 2 pages at the end of the the patent owner's response, and it does seem like a throwaway. Yeah. But in the life sciences, I have seen some very well done ones, and I would encourage you to think about using the narrative, telling the story of the success of your invention. Oftentimes in the life sciences, there is hard evidence of it. Get it in through an expert, and I will tell you, we look at it and it can flip the case. If it's a close case, especially in this life sciences area, it can flip the panel.
Thoughts on how you get nexus presented in the right way? Because that, I think, is one thing we continue to struggle with, particularly when the claims get lengthier, right? It's trying to go through each of those features and show, like, this is the feature that's really driving this and is the hook.
It can be the story. And I will talk about a case that I had probably 10 years ago. It's all done and it's been through appeals and everything. But it was an eye drop, a post-operative eye drop. And they had evidence that, people were not using this eye drop after surgery because it burned the eyes. And they came forward with abundant evidence that this was the first time they had compliance with post-surgical patients because they had a combination that didn't burn the eye. And they were able to show that, and it was extremely persuasive as a secondary consideration. And that's the kind of stuff where you can tell a story. If you have an invention that's really changing lives out there, this is where you can tell the story. And if it's a close case, and usually it is close if it goes to trial, and we actually have a trial, that kind of evidence can flip the panel.
I know the earlier panel was talking about sort of bringing in litigators and kind of preparing for litigation, and I think secondary considerations is something, if you're a prosecutor and you're working on a valuable portfolio, what I always counsel people is, you get a notice of allowance, and if you keep keep a file of whatever it is, praise in the industry or great study results and things like that, you can dump that into the prosecution file history as a comment on the notice of reasons for allowance and just say, hey, in addition to what you said, examiner, there's all this other stuff. And of course the examiner's right, they're not going to say anything, and it's in some respects self-serving, but it's in there. And then when someone comes along to challenge your patent, a couple years later, they need to address all that, which is going to make it much more difficult, right? Now they're going to have to fit in this secondary consideration argument. There's at least some evidence in the file history. So, it may not be something you do for every patent, but if you've got valuable portfolios, I think it's worth the extra effort.
So we want to pivot from sort of the evidentiary supporting pieces to the grounds, because we've been talking about some shifts in the law, particularly around 112, and you and I were chatting earlier that maybe we expect to see more 112 arising at the PTAB, and maybe you can share kind of what you're seeing as far as any kind of shifts in the filings.
I haven't seen any yet, but to be quite honest, I haven't read all the briefs that have come in the last month or two, but I am expecting to see more, arguments of intervening art so that we have to reach 112 in the IPR space after Amgen.
Yeah, have you seen any, because I'll tell you from a petitioner side, Amgen is juicy, right? The number of opinions we've written in this space, the thinking around it, everyone is like, this is great. This is a relatively straightforward way to get after some of the claim scope. Are you seeing an uptick in PGRs yet as a consequence of any of this?
I don't think so.
Okay. Interesting.
But I haven't looked at the latest data on that, so I haven't heard that there's been an uptick.
Mm-hmm.
Maybe Scott knows. Sometimes the private practice.
There's not an uptick yet, but I think it's coming. I know I've filed some PGRs, and I think Amgen is going to become a verb, with respect to the PTAB, right? I'm going to Amgen your portfolio. That's going to come. If you think about it, especially given what we've been talking about for the past couple of days with the IRA and other things, there's this tremendous upswell of, I don't know what you want to call it, a change in mindset, we'll say, from capitalism to more of a socialism, mindset of, drugs should be free and no one should really have to pay a lot of money for them. And so that you have these organizations out there that are going to have funding and, filing. Now that we're 10 plus years away from the AIA trigger date, there's going to be portfolios that have claims drafted in, the sort of functional style that didn't work out in Amgen. And if you can get a PGR in, or if you can get an IPR in where you're arguing intervening art and show that there's some enablement problems there, instead of wiping out one patent, maybe you wiped out the whole portfolio. So I'm sure there's going to be public interest folks out there that would be interested in mounting some of those challenges. Certainly there's going to be people in private industry that are going to do that. And even on some of the older portfolios, there's always a continuation patent that's popping out. So, you know, you're always going to have a new opportunity coming out to maybe argue this should be a PGR for, you know, because it's not supported by the earliest effective filing date, or like I said, it's intervening art in an IPR. But I think Amgen provides a lot of opportunity for people that want to do a lot of mischief to some of these portfolios. Yeah. And I think what's been keeping people away from PGR thus far has been, well, you know, there's this broad estoppel, right? If I file a PGR and I lose, it's going to be really bad. And I think we as attorneys often just copy and repeat things, and yeah, it's really bad, but losing is always really bad. And if you think about this, if you were to explain this option to some C-level executive, well, you know, we don't like this patent, we think it's got this vulnerability. There's two forums, right? We can go to this one forum where all the judges understand the technology. It's a lower standard of evidence. There's no presumption of validity, so that's the first option. The second option, the judges don't have any technical background. All the standards are against us, and it's 3 to 4 times as expensive. And the C-suite exec's going to say, well, this really isn't a choice, is it? And then the response is, well, wait, there's more. If we lose in the first forum, we can't argue it again in the second forum. And I think, the common sense response is, well, if we lose there in the forum that we have all the odds, we're probably going to lose in the second forum anyway. So, what are we really talking about here? So, I think at some point the light bulb's got to go on that, yeah, if you lose, it's bad. But, you never hear a litigator saying to a client, yeah, we can file this lawsuit, but if we lose, we're not going to be able to make that argument again. Well, yeah, that's the way it works. I think just as litigators, we're sort of accustomed as, well, we tease these things out. We don't make the arguments until we have to. Let's reserve everything. And so, yeah, having that second bite at the apple is appealing. But, if you're giving up your best chance, it's probably not the best strategy.
Right, and you have to lose all the way at the end, right?
Yeah.
So that means you got in. You had a good enough case
That's right.
to get going.
If you lose right out of the gate,
Yeah, there's no estoppel. Charlie, I see you. I'm going to get to you, but Vince has been waving his hand at me.
Yeah, I was just wondering if you could comment on if I get Amgen, especially on when we're thinking about retroactive effect, right? There's a lot of patents out there in existence today that are going to get Amgen. Do you think we'll see a trend where there's going to be a greater tolerance by the board to allow amendments as part of this process?
Judge Oberman, I'm going to kick it to you first. Maybe you're in the best position to answer this one.
I can't speak generally to whether we're going to see more leniency on amendments, if that's what you're asking. I honestly haven't thought about that, and whether, I think we'd have to take it on a case-by-case basis. But that would be interesting if people try to fix their Amgen problems through amendment at the PTAB.
Yeah, I think for most of our life sciences clients, right, we have the other problem that gets complained about right now, right, which is we have the never-ending stream of divisionals and continuations, and it's a much better place to address your issues.
Yeah. I could envision people, right, if someone in Amgen's your patent, and I guess you would save it by maybe converting it to a means plus function claim. I don't know, but from the challenger's perspective, that amendment's not necessarily a loss, right? If you just limit to the 4 or 5 examples you have and give up the other, whatever few 100,000 species, that's probably not a bad outcome for most patent challengers.
Yeah, it's got to be in that right spot for that, though, right?
Yeah.
A lot of our clients are like, no to the amendments in the first place. We'll go ahead and try this to even defend a dependent claim, for example, that's already on record, and say that's where our focus will shift versus necessarily trying to amend. But I think amending, right, gets you right back to having to make the 112 positions and support, and so you're going to have some.
And it's not so much that the PTAB is anti-amendment. It's in prosecution, right? I can amend my claims to say anything, and if they don't distinguish over the prior art, my amendment gets entered anyway. And at the PTAB, right, I have to amend and distinguish over the prior art. So that's why the amendment's not entered, because it doesn't distinguish over the prior art. So if we did that in prosecution, there probably would be a lot of amendments that don't get entered because they don't, they distinguish over the art. So it's not so much that it's anti-amendment. It's you've got a sophisticated adversary on one side, not some patent examiners trying to, do things as quickly and efficiently as possible. And, you have to not only amend your claim, but get over the prior art, have written description support and all of that stuff. So it's just not an ideal place as compared to prosecution that, I think gets lost in the shuffle.
Charlie.
I just wanted to drill into the 103, 112 tension, and I know in the quote predictable arts we've had success having our cake and eating it too, raising obviousness arguments, but also explaining why there's intervening art because there's some range that was added that's clearly not supported, or some open-ended range that's enabled for a portion of it but not the entirety. On the flip side, I'm not aware of good examples where someone has had their cake and eat it too on the unpredictable arts side, and I know we've on the patent owner's side leveraged an attempt to do that and got institution denied. But I'm curious if you see any scenario in which you could be raising both in a single PGR, say.
It's incredibly challenging, and what you almost always see in these cases is that somebody short shrifts for example, the obviousness position and the reasonable expectation of success, which then why run it in the first place? You have to get through that hurdle. But Vince and I were talking about this actually at the break, because the situation where it works, which rarely, I've never actually see it play out in the right way in the life sciences space, but it is that broad claim where a portion of it is enabled, but it's not across the entire scope. And you can challenge the breadth of the scope as lacking 112 support, but you can find the prior art that gets you the species, and not necessarily even in an anticipation spot, but just close enough where you can make the obviousness position, and that little leap, reasonable expectation of success, is easier to make because it's not going to actually kill your broader 112. It's a challenge. It's a real challenge. Have you seen one successfully completed that you can think of? No.
Yeah, I always wondered if you could, argue that, well, the priority document doesn't have 112 support, but it does teach, what's missing nonetheless. So therefore, that's you're using your own art against you, as though, well, you didn't show you had possession of it, but you kind of broadly taught it. So, that would be an interesting one.
Yeah, and of course, there are nice cases on continuations in part where that type of thing happens. The parent case makes for really nice art when the 112 support falls away.
Yeah.
So maybe we should turn a little bit to that tension, and what types of arguments we can run 112 in. And we both have mentioned intervening art. So I don't know if either of you want to kind of tackle that. I heard a panel, I think earlier this week, mention that 112 doesn't come up in IPR, and I was like, it certainly does. It really does. Intervening art is a great way to where 112 gets introduced. And of course, if you do the motion to amend, you have to also provide 112 support. So 112 does make its appearance in IPR as well. So either of you want to take, have comments on the first comments on intervening art and how to do the 112 challenge there?
I can offer my just quick thoughts. I guess ideally, I think that's how you would want to play, amgenning somebody's patent is you would be doing it in IPR, while 112 can't be an explicit ground. The way you do it is, well, you've got priority, at least facially, to, whatever, 2007. Turns out you don't have written description or enablement in that document. So really your priority date should be, whatever, 2-3 years later when you first presented the claims. And so there's this art that comes up in the interim, and we're going to apply that under 103. And so that 112 determination is made from a priority perspective, but it's not explicit, at least, like I said, in sort of a written description or an enablement ground. And so I think, given that there's less of an estoppel issue there, that, that's probably the way that you want to do it, and you can kind of think of it as, well, but what if I don't have intervening art, or the intervening art is not that great? Well, maybe I can get an advisory opinion out of the board anyway, right? I can file this petition, I can make my intervening art argument. They're not going to reach the art unless they agree with me that there's 112 issues. So even if they deny me, I'm going to have this document that says there's an issue here, but your art's no good. And maybe that's good enough for some challengers to just take that and say, go ahead, sue me, right? I'm going to find a way to get this into the record. I'm going to accuse you of patent misuse, blah, blah, blah. So you can dream up all kinds of, nefarious uses of some of these things.
One of the things I've seen is particularly in the life sciences space, right? We often are filing a first provisional, and then more data comes in and we file the second provisional, and then more data comes in and we file the third provisional, and then we ultimately get to the actual application itself. And, as a petitioner, I'd caution you, and as a patent owner, be watching for it, because really you need to be addressing each of those cases in between in what each of them establishes. So you could actually, you want to get back to Pro 2, but you got to go through Pro 3, right? So, or get rid of Pro 1. And so you need to address the whole chain and make sure you're not just skipping to the one you want to address so that you can get the date that you're looking for. And we've actually seen petitioners fail, not because, the argument might not have some merit to it, but because they didn't actually work their way properly through the priority chain to argue the date should be removed.
Mm-hmm.
Yeah, I've seen that, and I've also seen probably where someone's looking for an advisory opinion on the issue. Once or twice I've been on panels where we say, even if we accept the petitioner's date, this art is terrible and we wouldn't go forward, so you don't get your advisory opinion if you're in front of me.
Yeah, that would be the way to do it. Yeah.
Yeah, that's awesome. One of the other things I think is interesting when we're looking at, actually 2 additional points here on 112 positions, right? It's always worth keeping in mind that if you have a pre-AIA case or a transitional case that you're looking to kick into PGR, that you could mess with the priority date to make a case that on its face appears to be a case you would challenge in an IPR into a case you would challenge in a PGR.
Yes, and that's a situation that I saw quite a bit earlier, but probably like 5 years ago, where we would get the PGR and the IPR, and they would be in the alternative. So that's an example where we would have alternative arguments, and there'd be a PGR petition and an IPR petition.
And did those play out like?
Yeah,
were
we
there
would go either way.
Yeah?
Yeah, we would accept we wouldn't fault you for taking alternative positions in that. Yes?
Well, I was going to, on that, I have seen certain scenarios where panels did fault petitions.
Really?
And or note that under the AAA, you can't file an IPR for 9 months, so certain panels, I think, we're handling it differently.
Yeah, we just had a case last Friday that was a PGR that we got in that way, and it was basically an Amgen issue on transgenic seeds. So there's some activity out there.
Yeah. The other thing that I've seen some interesting 112, comments coming from the panels about is just how you run the 112 argument. And there are several cases out there, both from the PTAB and frankly at the Fed Circuit level and the broader case law, but make sure you're challenging the right thing. So for example, one context I've seen it in is a method, for example, of treating that uses a genus of compounds. And the petitioner's entire argument is around the genus of compounds, not about whether or not that genus of compounds would be expected to have the effect in the method of treatment. And so it's great if you want to run the genus of compounds is too broad, you don't have the support for that, but make sure you're tying it back to it. For some of those reasons, you also wouldn't expect, you don't have the full support for the method of treatment, because the claim is in fact the method of treatment, and the law says you need to consider the claim as a whole for enablement. So I don't know if you've seen some challenges like that where the phrasing and the argument is, on the right track, but doesn't quite reach.
Yeah, and I know the case, you had sent me a copy of the case that you're talking about. It was a Merck case from 2012, and, I think Jean said yesterday, quoting Judge Rich, the claim is the name of the game, and when you see this, it's because the petitioner's losing sight of that, and especially, that was an egregious example where the petitioner was focusing on structural compositions, and the claims are directed to methods.
Yeah, it was also it's an interesting case to look at because it also has the 112.103 squeeze going on it, where that particular petitioner did short shrift the unexpected results.
Yeah, it's not a precedential decision or even informative, but it's a good read, and I'll just give you the IPR number because I have it here. It's Merck versus Genentech. And it's a PGR 2021-00036. I don't have the paper number, but it was an institution decision, denying institution. Mm-hmm. And it's a good read, especially if you read it in the context of Amgen and Juno.
Yeah, and it has a sister case as well, which I think for those who are interested in the case number, the last number instead of 36 is 39. But it is an interesting case. Doreen.
Talking about the 112.103 squeeze, like sometimes in prosecution when I'm trying to make a decision, determining what the level of skill in the art can really affect that. Because of course you want it to be higher for 112, but you might want it to be lower for the obviousness. So how do you contend with that? And if the examiner sets a level of skill in the art during prosecution, does the board go with that, or how does that all play out?
So maybe we'll tackle that in reverse order. Do you credit the examiner if they talk about the level of skill in the art, and then do you see the level of ordinary skill in the art making a difference in these cases?
Almost never does a party or a group of parties establish that it would be different, depending on which we choose. If they're advocating different levels of skill, usually what I see is a petitioner coming in with a pretty detailed argument about the level of skill, and the patent owner will come back and say, we don't necessarily adopt it, but we'll adopt it for the purposes of institution. And even under that level, they're going to, lose. I don't know that I've ever seen a party argue the examiner's level of skill. I certainly wouldn't go back and look at it without a party telling me to or giving me arguments why I should adopt it. But to answer your question, I certainly wouldn't feel bound by it. If there was evidence put before me that it was wrong, I would look at it and I would accept that, at least one person, the examiner, thought it was appropriate, but I would probably have more evidence than the examiner to correct it if a party came forward with some evidence. So I'm always going to look at what the parties direct me to, but I'm not going to go out of my way to, look up the file history and see what the examiner said. Certainly not, unless a party directs me to it.
The other thing I've seen when the parties actually disagree, and it's at least a big enough disagreement to, because I've seen them where they're really small, right? It's like 4 years versus 3 years or something. You're like, really? But when they're different enough that there's some significance to it, I've seen the board say, we look to the art.
We do, but I will correct myself. There was one time where the parties argued over whether some practical experience in the particular field was essential. Okay. And it became important because one of the proffered experts did not have that experience, and there was completely contradictory opinions given, and we did give weight to the expert that had that experience. So that was the one time. So you do need to be careful, because if one of the parties, the petitioner in that case, threw in this necessity. It was the exact same ordinary, level, except that because it was such a particular, hands-on thing, you really needed to have some hands-on experience in the industry. And it was pretty stark because the two experts, one of them was really, had never practiced in that particular aspect of the technology. And that did end up giving the one who had that hands-on experience more weight when they were completely contradictory opinions.
Yeah. I really like this question because it's actually raising another question in my mind, which is often in the life sciences space, we have multiple experts who are coming at the same claim, right? It's a method of treatment using some biologic, maybe an antibody or, some peptide replacement, and we end up having an expert in the peptide and an expert in the, a physician. And how, do you have any tips on how do we reconcile that with the person of ordinary skill in the art? I know from our side, sometimes we've talked about it more like a team, which is a little bit more European flavor than what typically happens in the US. Sometimes we've said this person, this person is the expert, or the closer to the person of ordinary skill in the art, but don't disregard this other person because they're bringing helpful facts that you should consider. I don't know how.
I think there was a case, I wasn't on it, but I remember, Scott may remember it, there was a case where they tried to have a team situation for the person of ordinary. I don't think the board bought it, but I
don't remember that one.
You don't remember that one?
Mm-hmm.
I wasn't on the case, but I remember reading it when it came out, and I don't think that flew, but don't quote me on it. But I do remember they tried to have a team because you can get into a situation where you need both the, the physician and the scientist that created it, to sort of give you both aspects. So I don't have any good advice on how to address that. It hasn't happened in my cases. I've always been fortunate, I guess, that the parties have been able to resolve on a level of ordinary skill where they could have an individual. But my recollection is there was an attempt in one case to have a team, and I don't think the panel accepted it, but I just can't remember.
The one time I can recall that we sort of presented it more in that fashion, again, it wasn't an issue. It wasn't a point of contention between the parties, and so I don't think the board actually weighed in one way or the other.
Okay, maybe that's the case I'm thinking of.
So
yeah, I don't know, because I think there was only one case I can recall where there was a team, and I just don't remember how it resolved.
Yeah. Scott, do you have this, the multiple experts, and how do you think about the person of ordinary skill in the art for setting these stages?
You don't see it as much in the predictable arts. Occasionally there'll be some hybrid technology where you need sort of, like a circuit person and someone else more on the software side, but not too often. And I've also seen more so on the patent owner side where, they'll just get 3 experts all saying the same thing. It's like, well, we have 3 experts, you have 1, so we win. And I think in general in the predictable arts, you probably get a lot less mileage out of your experts. It's not to say that the board doesn't value them, but I think it's more often than not, on a lot of cases, that the judges sitting on the panel will have relevant experience. And so I think, they can, when you have an expert that's saying, well, up is really down, I don't need to try too hard to beat that expert up because I know the panel is just not, they can read the reference and see that that's not the case. So I do think in the unpredictable arts, it's a much different game. The experts are critical. You're talking about niche technologies. The panel may very well be scientists, but they're not going to have that kind of experience where if you're arguing over 2 interfaces instead of 1, right? Everybody can get that. So I think it's a lot more critical in the unpredictable arts.
I just want to emphasize, because I think Scott made a really good point, because I do see that where an expert will try to make a sort of an esoteric argument, but if it contradicts the intrinsic record, I'm going to reject it. And I'm going to reject it on that basis, that you can't sort of contort the intrinsic record or manipulate it through opinion testimony that doesn't jive with it. And that happens quite frequently in this space.
Interesting.
I always call it the sort of the my cousin Vinny defense, right? It's like You know, you've got some plaintiff's lawyer just sitting back, well, everything that guy said is bullshit. And, you know, the declaration is the exact opposite of every position you've taken, and I think they're just accustomed to, well, I've got clear and convincing evidence, I got presumption of validity, here's 30 arguments, you know, disprove all of it, and I just don't have to if I'm in front of people that understand the technology.
And keep in mind that we focus like a laser beam on that intrinsic record. And the expert stuff is great if I want to look at it, but I can usually figure out where I'm headed. And when I approach a case, I don't read the briefs first. I read the patent, the claim, and the prior art that's asserted in the challenges, just to get a feel for, you know, how far it looks like from the claim. And then I start reading backwards. I'll read the reply brief, I'll read the response, and I'll read the petition. Because the reply brief usually really flags for me what the
key
real,
dispute.
you know, heart of it is. So you're dealing with judges that are approaching these cases very differently at the PTAB than you would at the district court.
Yeah. I'm intrigued that you said people are putting in 3 expert texts that are on the same point. I mean, we usually try to very carefully craft around so that they're not overlapping in testimony. And the last thing I want is to go into depositions and have 2 people going wild card in different directions.
Yeah.
So.
Yeah, it didn't work out for them. But, yeah.
Yeah, so excellent. Well, Jean, I think we've covered most of our topics. It looks to me like we're close to time. I see Renee walking at us, so
Yeah,
I mean, we can keep going, but
No, we're pretty close to time. The one question that I did want, just so there was some continuity between you guys and the last panel, was if you have any thoughts on whether ANDA filers should, whether they should be at the PTAB, whether they should, second filers should be filing at the PTAB, any of that stuff, because it still amazes me that you get people in the ANDA world going to the PTAB, but I mean, and not because the PTAB wouldn't be useful to beat these patents. I do think in the life sciences area, the patents fare better than in other areas, which is probably not surprising because there's so much at stake. So you put a lot more effort in on the front end than you might on other areas. Yeah. But what surprises me is that a generic would make the choice to go and kill the patent and then open it up potentially for everyone and not just themselves. And that's the thing that we didn't anticipate 12 years ago when the AIA was kicking around.
I think my concern if I was in an ANDA dispute right now is like I said, some organization popping up out of the ether saying, oh, this is an important drug, and, you know, they're charging a lot of money for it. I'm going to try to Amgen it and, you know, right. Save the world from this high-cost drug. And I think that we may see some of those organizations popping up here. And you know, there's been a lot of talk about standing and the PTAB, and the agency is kind of looking at that now. And I don't know that they can go as far as to require standing, but I could see threading the needle a little bit and getting into discretionary denials on, well, this seems like you know, a perversion of the patent system. Not sure this is worth our resources. So, you know, maybe that's something that'll happen down the line. But I do expect to see some, you know, like I say, public interest organization try to do some of that kind of stuff.
So I hear you saying that Amgen is going to become a verb.
Mm-hmm.
It's already there, apparently.
Maybe,
Yeah. This panel's established it.
It may be an adjective, too.
Yeah, yeah, I made it a verb, at least for one client.
Yeah. So, yeah, and I suspect you're probably going to do that more often. But, and so, I mean, I really worry about Amgen. I hear everybody saying, oh, well, you know, it's not a lot to see here. It's always been the case and so forth. I just have a real sense of how that's going to get misused. And maybe not misused. I think the case goes a lot further than a lot of people seem to think. I sense you agree.
I mean, you
with
can
me.
argue the law hasn't changed that much, but I think it has put a focus on claim drafting practices, and you know, that's going to catch the eye of the agency more so than it would in the district court. So
It's more of an increased prominence
Yeah.
in everybody's mind. It's at the front
and
of
you've got an
everyone's
inventory of important patents that were drafted that way for a reason. And, you know, like everything in patent law changes, you know, means plus function 101, and patents that were drafted that way, you know, 10, 15 years ago made perfect sense, and now they're vulnerable.
And that's the frustrating thing is patents that are litigated are usually about 10 years, 8 to 12 years old, 10 being very common age. I don't know that we're going to see all this fall out for another decade, really.
Yeah.
And then in retrospect, I think what we'll be here is saying, Amgen, that was really a terrible case, because there's nothing, and I don't even know how you could at the PTAB correct through amendment an Amgen problem. I mean, because it's fundamentally a problem with your disclosure, right? What you've put in the specification. I don't know how you could fix that with claiming and add new matter. I suppose the way it would be to narrow the claim, right? But
Yeah.
but what you wanted to claim is gone, right? So the fact that maybe you could
Yeah,
save
saving 6 species out of 600,000 may not be.
right, but wouldn't most pharmaceutical companies already have a claim specifically on that? I mean, don't you
Almost always, yeah.
Yeah.
Almost always, right? I mean, whatever the FDA has allowed, you make sure you have a claim on that, like Phil was saying earlier. So saving it by narrowing it doesn't seem to me to be much of a consolation prize, because it's like you've already got that. You probably deserve to get double patenting on that because we've already given you that patent.
Well, then you select them.
Right.
That's another verb.
Yeah.
Wow.
And on that, I think that's probably a good way to end. So select and
Amgen
Amgen
are
are
now
now
new
verbs.
verbs for
Yeah.
life sciences.
Yeah. All right. Well, thank you very much, panel.
Thank you,
Thank you.
Gene.
Thank you.
So, and that brings us to a conclusion. We are now wrapped up. We stand adjourned, and I hope all of you will join us for lunch. Thank you.